In the box, Michael, in the box.
All right. Oh, and
Okay, so I'm going to put my hands on my speaker.
okay. Ladies and gentlemen, I'm Professor Michael Scharf, Associate Dean for Global Legal Studies and Director of the Cox Center, and this is...
I'm Avi Cover. I'm Director of the Institute of Global Security Law and Policy, and we're thrilled to have you all here.
So welcome to Case Western Reserve Law School for a very special event. This event is being sponsored by our Institute for Global Security Law and Policy and our Cox International Law Center. So Avi and I are partners on that. The Institute for Global Security Law and Policy was created shortly after 9/11, and it has been doing a lot of really exciting things involving the struggle for national security and against terrorism. So today we have an incredible speaker that is going to be telling us about some things that I don't think anybody here knows much about. Let me tell you, it's stuff that has not been front page news, but it's really exciting behind the scenes things. Let me start off by saying that I've known Kim Prost, our speaker, for many years. She used to be the head of the Canadian office in their Department of Justice that does international affairs when I was back at the State Department doing law enforcement and intelligence. Later, she became a judge of the Yugoslavia Tribunal, which has been prosecuting many of the people responsible for atrocities in the conflict in the former Yugoslavia. Then, after her stint was done there, she was given a new position that had never before existed, which is the position of Ombudsperson for the UN Security Council. And what this position does, and you'll hear more about it from her, is basically as follows. The Security Council has passed some resolutions that say that if you are a member of Al-Qaida or the Taliban, or a supporter or an affiliate, then your assets get frozen around the world, and every country has to freeze and seize your assets. And moreover, another Security Council resolution said you're not allowed to travel anywhere in the world. There's a travel ban. Well, there's a lot of people that were listed, over 375. Some of those people said, we just were caught up in this list. We didn't get due process. We're innocent. And so the Security Council decided to create this position of ombudsperson to go case by case and basically be an appeal to decide who should not have their assets frozen and be subject to this travel ban. Now, the only way the decisions of the ombudsperson can be reversed is by unanimous decision of the Security Council, something that you almost never see. So it's a huge amount of power. And what Kim Prost is going to tell us about today are some of her insights about the operation of the Security Council from her years as a judge at the Yugoslavia Tribunal and now as the ombudsperson for the Security Council. Please join me in giving a very warm case welcome to our honored guest, Kim Prost.
Still have my rock and roll museum tag on. Well, good afternoon, everyone. It's a real pleasure for me to be here at Case Western. I'd like to thank Professor Cover, my old friend, old as in long time, Assistant Dean Scharf, for inviting me and for the tremendous hospitality. I've had a terrific time already here in Cleveland. I'm going to go back to New York to promote Cleveland and Case Western. So, and it's always a great opportunity for me to have these occasions. The job that I currently occupy as ombudsperson is a very lonely job. And I, up until about 8 months ago, I was on my own. I've been doing this just a little over 3 years. I had no one at all in terms of staff. I now have a legal officer. And so this is a great opportunity for me to talk a bit about the work and the operations of the office in the context of the council. And also just to talk today, I'm going to speak a bit more broadly about the Security Council and some of the innovations in the Security Council, including my office and the work of the tribunals. So, and I realized it's a very timely opportunity to speak about the Security Council For anyone who's following international news in the press these days, there's been a lot said about the Council, a lot not particularly positive necessarily. And I think in times of difficulty for the Council, it is important to reflect not just on the challenges, and there are many for this highly political body, but also to reflect on some of the innovations and successes of the Security Council, which is what I want to try and do today, because it is an important body within the United Nations, and I don't think we can ever lose sight that this was a mechanism born of two catastrophic world wars and of a time period when the world was very much in tatters. And so I think it is important to bring that perspective, and especially for the young people who are here today, because we can't lose sight of the role that the Council plays in a positive sense. So I'm going to speak a little bit about the two areas that I think represent some of the innovations and important innovations of the Council, and I'll tell you a bit about the world of Al-Qaida and the Ombudsperson. Now, the Security Council, as you all know, is the body of the United Nations, which under the Charter has the primary responsibility for dealing with threats to international peace and security. It's to identify and respond to those threats, and has a full range of powers, from the ability for pacific activity for settlement, through the imposition of economic sanctions and general sanctions, which is something I will speak about, to military intervention. And since almost its inception, the Council has used its powers, both those accorded explicitly and in innovative ways. In 1948, and it's something that all Canadians always speak to about the Council, they used the concept of the military powers to send observer missions to the Middle East and to Pakistan, which were the beginnings of the peacekeeping role that the UN still plays to this day all over the world. And it's important to Canadians because Lester Pearson, who was one of our prime ministers, won the Nobel Peace Prize partially for his role in that activity, in the starting of that program. By the 1950s, the Security Council had already invoked its military power with the intervention into the Korean crisis, which took place at that time. And it used, from early days, it was using its sanctions power in the context of the struggle in South Africa in reaction to the apartheid of the government of South Africa. So right from the start, the body was, I think, important and did play an active role in international matters. But it's really in the 1990s when there was an unusual, for our world, rapprochement, if you want, politically, end of the Cold War, massive changes with the end of the Soviet Union and the transformation in that context, that the Council grew more active and quite bold in many ways. And the watershed, in my view, moment for the Council came in the face of the brutal conflict in the former Yugoslavia, first Croatia, Bosnia and Herzegovina, Kosovo, former Yugoslav Republic of Macedonia. There was a conflict that had the potential to destabilize the region and really was a significant threat to international peace and security. And perhaps it was because of the nature of the conflict, perhaps it was the history of that region and what it had represented in the context of the world wars. But for whatever reason, the Council began to take some extraordinary steps. First, they sent a commission of experts in to look at the question, not so much of the broader questions of peace or resolution, but the questions of crimes, whether war crimes and crimes against humanity were being committed in the area. And in response to the report, which confirmed those activities, on the 25th of May, 1993, they adopted quite a historic resolution, Resolution 827, which overnight created the International Criminal Tribunal for the former Yugoslavia, on which I served for 4 years as a judge. And it was followed less than half a year later in 1994 in the face of the horrific genocide in Rwanda by the establishment of that tribunal. And the important thing to recognize here, and especially for young people who I speak to about this, the tribunals have been in existence for quite a while, so to some degree people accept them as part of the landscape. But this was an extraordinary step by the Security Council, particularly given that nothing in the Charter, nothing in Chapter 7 talks about establishing a court. And what the Council did was something that they tried to do at the time of the Charter, create a international criminal body, and they were unsuccessful in doing it. Overnight, it suddenly appears. Now, the ramifications for international humanitarian law, international criminal law, have been mammoth. I don't think anyone, even the staunchest critics, and there are many, of the work of the tribunals cannot detract from the fact that the tribunals have contributed an enormous amount of case law. These were the first tribunals post-Nuremberg, post-Tokyo, to deal with individual accountability for crimes of the gravest nature. And we have that body of case law due to the action of the Council in creating the two tribunals. Also important contributions to peace in those regions and to justice. And most significantly, one of the main impetuses, we had a window in the world when forces came together and allowed for the negotiation of the Rome Statute for the International Criminal Court. And in no small measure, we have today an International Criminal Court because of the steps taken to create those two tribunals and what they showed the world about the possibilities of individual accountability in this context. Now, you will hear lots of discussion. It's not the best time for international criminal justice today. You'll hear lots of critiques of the International Criminal Court. But at the end of the day, I'm the staunch believer who says the world is a much better place with a possibility of justice, with the possibilities that the International Criminal Court presents than without it. So that body of activity started by the Council's actions, I think, is one of the last century's and into this century's most important steps forward in terms of international humanitarian and criminal law. And it's also interesting, people forget the implications in terms of the Security Council. This was a pretty dramatic step that they took. The Tadic Court dealt with the question of whether the Council had the ability or the jurisdiction to take the action that they did. It's not surprising that the judges of the tribunal found that they were properly constituted, but it's still an important decision that reflected that the Council could take these kinds of innovative actions and successfully do so. And it was also a change in how the Council and the Security Council was interacting with states. At the time, as Michael mentioned, I was head of Canada's International Assistance Group. And I woke up one morning to find that the Security Council had just said, in a binding way, that every country had to be able to cooperate with this tribunal. This wasn't just about setting up a tribunal. Countries had to be able to turn people over and had to be able to turn evidence over. Well, I tell you, I had a few nightmares about that issue because the legislation in Canada certainly permitted me to arrange for extradition to another state and arrange for the sharing of evidence with another state, but there was no capacity to compel someone to go to the tribunal or to compel evidence. And I must say that the Canadian efforts to change legislation, which every country had to undertake, took much longer than I was very comfortable with. They enacted the legislation about 2 months after I left. I don't take that personally, but still. But it gives you a sense that this was the Security Council, in essence, starting to mold domestic law in a way and mold international cooperation in a way. They did something similar only once since, in my view, and that was in 2001, after the tragic events of 9/11 with Resolution 1373 on counterterrorism, where the first paragraph of that resolution requires all states to have a terrorist financing offense. That was a remarkable action by the Security Council, again directly implicating domestic law at that time in response to the threat of counterterrorism. So I cite those as examples of what I think are sort of positive driving steps by the Council, changing a bit the way the Council interacts with states, and certainly creating an important step forward in international criminal and international humanitarian law. But at the same time, I'll move into the world that I now occupy. At the same time, it was business as usual for the Council in terms of its traditional powers of considering international threats and imposing various forms of sanctions in various forms of measures. And they were increasingly resorting to the use of sanctions, powerful economic sanctions, in the face of what are today increasingly complex security threats in our world. But as the use of sanctions grew, as with anything, the unwanted, if you will, side effects of the use of the Security Council's sanction power became clearer and clearer and began to be the subject of criticism. When you impose, and we see it today with Iran, when you impose massive economic sanctions on a country, you certainly can have an effect in terms of trying to change conduct and in trying to restrict their ability, in the case of nuclear proliferation, whatever it might be. But at the same time, it does have a devastating effect on a mostly innocent population. And that was the problem that the Council, the Security Council, had to try and address. And they were very cognizant of the effects, Libya, Iraq, of the effects of the sanctions, which they viewed as necessary. So they began, and it really began again in that period in the 1990s, using what are referred to as smart or targeted sanctions. And what those involved is, rather than employing the sanction against a whole country, a whole population, they would direct the sanctions at factions, governments, government officials, individuals that were responsible for whatever the conduct might be. They were used, for example, in the former Yugoslavia conflict. They were used in the context of Haiti. And it was a very important innovation for the Security Council. And I took the job that I currently occupied, one, because of my belief in the need for rule of law principles at the international level and fair process. But I also took the job because I believe strongly that the international community and the Security Council should have at its disposal as many weapons as possible. I sat for 4 years on a genocide trial out of the Srebrenica massacres, and I am strongly of the view, whatever powers are possible, we need to have those in our arsenal to deal particularly with international humanitarian violations. But at the same time, the use of those powers has to be done in a credible and effective way, which is part of what motivated me to the job that I now occupy. And the problem that arose in terms of the use of the sanctions, it's a problem that probably crosses all of the sanction regimes, but it was a particular issue in the context of a resolution which is referred as Resolution 1267, which we now call the Al-Qaida Sanctions Regime. And I'll talk a bit about the origins of it because it'll give you a context that's important for the fairness issues. So in this context of targeted sanctions, in 1999, there had been investigations in Kenya and Tanzania in relation to the bombings there of the American embassies. And the investigations had determined that Osama bin Laden and Al-Qaida were responsible for those particular horrific acts. And as a result, the Council adopted a resolution which was aimed at trying to get to bin Laden, who was in Afghanistan at the time. He was being sheltered by the Taliban, who had control of much of the country at that time. But instead of placing the sanctions on Afghanistan as a whole, they placed them directly onto the Taliban. They placed the 3 traditional forms of sanctions: economic sanctions, so freezing of all your assets, travel bans, so you can't travel anywhere in the world, and thirdly, a weapons prohibition. And they created a committee which would be responsible to designate who's a member of the Taliban. And that it wasn't a particularly controversial move by the Council. It was a form of targeted sanction. And then there was what at the time seemed small and innocuous, it doesn't seem so today, amendment in 2000 when they added Osama bin Laden and Al-Qaida itself. So it was now the Al-Qaida and Taliban regime. And the tricky part was that was the first time the Council ever employed sanctions on non-state actors. Because as we all know, Al-Qaida is not tied to any particular state. It was not like the Taliban at the time tied very much to Afghanistan. You could be from anywhere and you can be a member of Al-Qaida. And that would come to be a very tricky issue, as I'll highlight shortly. But still in 2000 it wasn't particularly a difficulty because there was a handful of people on the list and most of them were in Afghanistan. But again, we have the events of 9/11, and events of that catastrophic nature often have an impact in terms of the Council, Security Council, and the activities taken at an international level. And hundreds of names went on to the Al-Qaeda Taliban sanctions list after 9/11 within weeks, particularly those believed to have been financing Al-Qaida. So you have people all over the world suddenly on this list. And what starts to happen, because the Council runs this, even though they're targeted sanctions, it's business as usual for the Security Council. So they're not explaining themselves, they're not sending notices, they're not talking to people, which isn't something the Security Council does, they talk to states. So suddenly, you did have situations where you could go down to your bank and try to move your funds and find out that all your assets were frozen. No one could quite tell you why. The government couldn't tell you why. There wasn't reasons at that time published. You can imagine, and there was no recourse. There was really nowhere you could turn other than to your government to ask them to speak to the Security Council, which is fine if you're in Sweden. But if you know, anywhere else, it's iffy whether they're going to actually take some action and try and get the council to give reasons or explanations or give you some form of recourse. So the criticisms of the use of the sanctions, and here it's why that amendment was so important, because in a political context, when you put sanctions on states or you put them even on a faction or government actors, there is a form of recourse because there is the political avenue. You can have debate and discussion with the council. Your representatives can go in and speak. But if you're an individual, you have no such access. So the criticism started almost immediately. There was states were in an uproar over how to deal with implementation. Academics began to take up the cause of, you know, you can't have this complete void of transparency, lack of transparency, lack of fair process. And the Security Council did react to that. Over a period of time, they took some measures. Today, if you Google the 1267 Al-Qaeda regime, you'll see a listing of all the individuals who are sanctioned and what we call the narrative summary of reasons for those sanctions. And you will also find now that there's attempts made to give notice to individuals. There's a review process that the committee itself carries out. But still, and they created a focal point as well, someone you could write to, but she's a lovely person. I don't like to refer to her as a mailbox, but she's responsible simply to take communications and pass them to the committee. So in the sort of tipping point for all of this, because the view was this was still not enough, there began to be court challenges. There was a case in Canada involving a man named Mr. Abdul Razik who got stuck in Sudan. The Canadians wouldn't bring him back because he was on the list, even though he was a Canadian, so he's living in the embassy in Sudan. He sues. And then there was a man named Yassin Qadi, who's a Saudi millionaire, who was put on the list in 2001, and he began a case in the European Court of Justice. And in 2008, to everyone's surprise, I would say, in terms of traditional international law, the European Court of Justice found that even though there is Article 103 of the Charter of the United Nations, which says that the Security Council and Chapter 7 decisions trump and that the UN trumps, they found that Mr. Caddy was being subjected to these measures through a European Union regulation, and it didn't matter that it came from the Security Council. There was no recourse, there was no fair process, and they struck it down, which meant that 27 countries of the European Union could no longer implement the Security Council's resolution. That got attention, to say the least. And I'm where I am in New York, because the Office of the Ombudsperson was created in December 2009, not because of the Caddy decision, because of the need for fair process and the recognition of that need, but the court decisions were clearly a factor, a motivating factor, if you will. So what does this office do? Well, I take applications from individuals. They can come directly to me. If you are on the list, you can come directly to me. Most of the applications I receive come in by email. Sometimes people phone me and we help them put together an email. They don't need lawyers. About half of the applications so far have had lawyers because my role is as an ombudsperson. I take the case, and if I'm satisfied, all they have to do is explain to me why they shouldn't be on the list. So they have to address the reasons that are out there for why they are on the list. And then I start a process whereby I gather all the information about the case. I send out letters to states. I look online. I go to organizations sometimes. And it's interesting, I get very good cooperation. I mean, I used to have a subpoena power, and I miss my subpoena power. But I must say the combination of being created by a Security Council resolution and being very, very annoying gets pretty good responses, because they know if they don't answer me, I'll phone them and then I'll come and visit. And so I do get responses. But the real challenge, as you can imagine, in the information gathering is that many of these listings are premised on intelligence information. And that means the information that they're prepared to share, many countries are prepared to share, is very vague. And it's certainly not necessarily sufficient to be maintaining a listing of this nature. And so one of the big challenges, it still remains a challenge, is trying to get access to that confidential information. I now have about 12 agreements, including with countries like the United Kingdom, France, Germany, but there's one big one missing, and I bet you can guess which one it is. So we're still working on that. But when I gather as much of the information as I can, and the whole philosophy I had from the time I took up the position was, I'm going to take what the Security Council gave me in the resolution, and I'm going to use it as much as I possibly can to meet those fundamental principles of fairness. So know the case against you, have an opportunity to respond to that case and be heard by the decision maker, and review by an objective individual or entity. So after I gather the information, I have 4 months to do that, and I can extend the period once, but that's it, for 2 months. And then I move to what's called the dialogue phase. And in this phase, I actually engage with the petitioners. In the resolution, which I'll speak about in a minute, that changed the process in a pretty dramatic way, the Security Council also encouraged me to go and meet as many of the petitioners as I could. Now, obviously, they can't come to me. It's a little tricky. So I do go to meet with the petitioners, and it's quite a remarkable part of the process. And it's during that phase that I put to the petitioner everything I've gathered, unless I have confidential material. And they then have an opportunity to tell me their response and what they want to say to the committee. And it's interesting because several of them have said, including Yassine Caddy, who did bring an application before me, who I interviewed for a day and a half, and he and others have said, you know, I've been on this list for 10 years, and this is the first time anyone has sat across a table from me and asked me questions and heard my side of the story. And for me, that's a really telling statement about why this is such a necessary measure. Put everything else aside, that's why it's so important for fair process. So once I've gathered that information and the information from the petitioner, then I prepare the comprehensive report that goes to the committee, because it is still the committee's decision whether to delist or not. However, when I first, and Michael's talked a bit about this, when I first took up the job, and it was a big risk in many ways, because Many thought that the resolution did not go nearly far enough and that this was just a fig leaf. Well, I don't like being called a fig leaf. So when I first took up the job, I didn't have the power to make a recommendation. I could make observations. But I figured, well, you know what, I don't think they brought me here to give a fact summary, so I don't care what we call it, but I'm going to tell them what I think, which is what I did. And so that didn't go over so well in some quarters, but they sort of got used to it, and I think the attitude really was, well, if she's going to do it anyway, we might as well get the credit for it. So in the renewal of my original mandate was for 18 months, although I got there 6 months in, so it was about a year. In June 2011, they gave me the recommendation power. But more importantly, by then, the European Court of Justice had struck down the regulation. Council had tried to amend, the European Council had tried to amend it. ECJ strikes it down again. So there's a lot of pressure on. And so the resolution, and I got a call late at night telling me that this is what I was going to get, which was quite a shock to me. It gave me the trigger power that Michael spoke about, which is I now make a recommendation where I recommend delisting. The person or entity will come off the list in 60 days unless there is a unanimous decision. Yeah, it's, tough. To the contrary, or it can be referred to the Security Council for a vote. But that's a very significant political step to take for an individual case. So that was the compromise which was achieved to try and give more, if you will, sort of more independence, more emphasis to the role of the Ombudsperson for fair process purposes. The two things, unanimous overturn and Security Council reference, have never happened. So since the time of that resolution, my recommendations have been effectively carried out by the decision of the Security Council's committee. And it's interesting because the other sort of aspects of this, I, from the start, have said the Council did not give me a power of judicial review. I think that's politically very unlikely, if not impossible, that they're going to let an outside party review the actual decisions of the Security Council. So what I say is I'm not reviewing anything to do with the original listing. I'm simply asking the question today, presently, looking at the information, is it, and I made up a test, okay, I admit that. There was no standard, so I just made it up. And the standard I employ is whether there's sufficient information to provide a reasonable and credible basis for the listing. Sort of a mix of common law, civil law, got words in it that everybody recognizes, seems to work. So that's the test I use, and that present day assessment is now in the resolution because it's of some comfort that this isn't a review of the Council, it's an independent de novo assessment of the information. The other important thing is that I made it very clear that I will do these assessments solely on the information that I gather. So it's not open to a state to say to me, we know things, and you should rely on us in terms of things that we say about information that we have. Bottom line is, you share the information with me. You can do it such that I'm the only one who sees it, fair enough. But otherwise, I make these decisions, my recommendations on the information gathered. That's the only fair process for the petitioners. And then the trigger mechanism could operate. So that is a real impetus for the states to be able to provide me with confidential information, which is why discussions with the United States continue on that very important issue. And also, I really want to know what the full facts are. This is, at the same time that it's important to fair process, it's a pretty heavy responsibility. I don't want to be the one delisting somebody when there's strong information that should keep them on the list. So for both reasons, I am hopeful that we can try and find better ways forward in terms of access to information. I'll give you a few statistics and then just identify a few issues and open it up for some discussions. I've had 50 cases so far of the approximately 375, which I think is pretty good. 32 cases have been completed. Now, some of the cases involve applications by an individual and several entities, so the numbers don't exactly match, but 26 individuals have been delisted. 25 entities have been delisted. One entity was removed as an alias. It wasn't an actual removal of the main name, but still through my process. In 3 cases, there was a denial of delisting, but in one of those, it was before the recommendation power, and there's been a subsequent application, and he was delisted. One petition was withdrawn, brought again, and they were delisted, the entity. 3 cases have been concluded by a separate decision of the committee. So my process starts, and then the committee takes the decision to delist of its own initiative. That included the case of Osama bin Laden, whose application was brought just recently, so well after he was reportedly deceased. And 15 cases are active at the moment. So I think when I look at the body of the activity and I look at it, stepping back again into my broader topic today, I think both the use of the targeted sanctions and this remarkable steps the Security Council, and they are remarkable and perhaps underappreciated. The European Court of Justice just recently issued another decision. They seem unmoved by what the Council has done. I think that's an underappreciation, with great respect to the Court, of the extraordinary steps the Security Council has taken. They make no mention of the work of the Office of the Ombudsperson, and I think, putting aside whether you think ultimately it's sufficient, that there should be recognition that it has brought a level of fair process. I've been satisfied in each of the cases on a practical level that the individuals have had a fair process in line with those principles I described. But the court, at least the European Court of Justice, is not yet convinced and considers they have to review the underlying information, although what they suggest in terms of how they will access confidential material, I think we'll have to see how that works out in practice. The Special Rapporteur of Terrorism and Human Rights wrote a report on the office last year, was pretty positive in many respects, but was of the view, because there is still the potential of a Security Council override, it's not enough. I respect Ben Emerson. He's a terrific human rights lawyer. I respect his position. I don't necessarily, I don't necessarily agree that that has to be the test, but I certainly understand those concerns. So there's still issues about whether this is sufficient, but I do think that when I look back to 2010 and I look at those 50 applications and those 32 completed cases, I think it's remarkable progress in the terms of rule of law, credibility of the regime. I'm going to stop there on the role of the Ombudsperson. In closing, I just wanted to highlight again that, it's unquestionable that the Security Council, which is a highly political body operating in an increasingly complex world, is going to continue to face frustrations and challenges, and perhaps some of those challenges are insurmountable. It's always going to be controversial. It's always going to be criticized. But especially what shouldn't be lost in the valuable debate that surrounds the Council is that we must ensure that it's a balanced discussion that recognizes the strengths of this body as well as its weaknesses. And I started in the same position I am on the International Criminal Court. Our world, our global village is a much better place with the United Nations and a Security Council than it is without one. So to the young in the room, it's your job to make it all better. I'm happy to take any questions and comments, totally open if you want to ask me things about the tribunal days as well. The only thing, someone's very anxious. Only thing is there may be some things which, because of the position I occupy, I work with the Security Council's committee, not for them. There may be some things I simply don't feel appropriate for me to comment on, and I'm sure you'll all understand that, but I'm happy to take the questions and comments, and we'll see where we get to.
Yes. I believe you said that the financiers of Al-Qaida are put on a list. Not just Al-Qaida, but the financiers of Al-Qaida. So is there at least one nation on the Security Council that is financing Al-Qaida in the bloody civil war in Syria? And if so, should the persons responsible for this be put on a list?
Well, I'll comment on the first part of your question. The criteria for listing that has been set by the Security Council is association to Al-Qaida, and it is defined as any form of support, in essence. So participating, preparing, financing, all of those activities are part of the definition. It's not dissimilar from what you would know in United States law as the material support provisions. So yes, individuals stated to have been involved in financing Al-Qaida or entities were placed on the list, and some of the narrative summaries still talk about that as being the basis for the listing of some individuals and entities. On the broader question, this is a list that deals solely with individuals and entities. So I don't deal at all with the question of state responsibility. That's entirely outside my realm.
Is a state composed of individuals? What do you think?
Well, it is, and definitely, but as I say, there is this distinction. This is a part of a targeted sanction regime, as opposed to, for example, there are regimes which are aimed at, sanction regimes aimed at states, but totally outside my realm of expertise and responsibility. So on that one, no comment.
Okay, thank you.
Quick, interesting question is, I saw you mentioned bin Laden was taken off the list.
Yes.
Did someone apply to have him taken off? And I'd be curious why anyone would care if he's off the list. I mean, after all, he can't go anywhere. He swims with the fishes.
Yeah.
You know? But his money might matter.
He was removed by virtue of a decision of the committee, and it's an issue. There has been an issue about, and the committee carries out a review of individuals who are listed who are said to be deceased. Because this is not an asset regime. It involves the use of a sanction measure of freezing assets, but it's an individual or entity-based regime. So you have to be, supporting Al-Qaida to be on this list, and those who are deceased obviously no longer meet, in essence, the criteria. But there is great concern, and there certainly was in the case of bin Laden, which is, why it took some time before he was removed by the committee, because of the asset issue. And so they had to be satisfied. The Security Council added a section to the resolution which specifically said states must ensure and report on what are done with any assets being unfrozen as a result of his delisting. So that was an extra caution in his case. I think totally understandable, given he was at one point part of the criteria for listing. And why does anyone care? Because it's a part of the credibility of the regime. And all of the Security Council recognizes that. This is the sanction regime, so deceased persons, everyone accepts deceased persons should not be on the list. You deal with the assets through these kinds of measures. The difficulty is, of course, it's sometimes very difficult to determine if someone is really deceased. And there's also, as I say, sometimes it can take a while because of concerns about the assets. Okay? Yes.
If someone gets delisted, do they get like a certificate or something? Is there document?
No, it's actually a really good question, because one of the issues, and I report twice a year to the Security Council. I don't report in the sense of, waiting for them to say yay or nay on my activities, but I write reports on my activities. And one of the things I've talked about is that there is a problem in terms of follow-up and implementation of the decisions. So I've certainly had, and I've written about this in my reports, several petitioners who've come back to me and said, listen, I know I was delisted because you told me so, and I have a letter, but I go, I try to enter country X, and I'm told I can't enter because of the Security Council listing, or I can't get the bank to release my funds. So I actually do, on occasion, write a letter to try and assist, but so far, despite my asking, and I continue to ask, the Security Council has not given me a direct power to sort of intervene formally in those situations. So I just try and do the best I can informally. But they certainly get notifications, and there's a press release and material we can send to support that.
I'm surprised that there aren't more people on your list, because Al-Qaida seems to be thriving anyway. and I wanted to know who advocates for you and your position to enable you to have more power.
Oh, okay. Very good questions. Yeah, and it's interesting. I mean, this is not an exhaustive list by any stretch. And like any other act of the council, the determinations to list people are based on the criteria of the Security Council, but there might be reasons that they don't want to include certain individuals or certain entities for other reasons. You know, sometimes it might be counterproductive. Can be some of the splinter groups. The council might have, you know, very good reasons. Perhaps they're involved in, you know, some kind of a peace process that, you know, where they're trying, I think, for example, some of the groups in the Philippines, for example. I'm not saying they were ever contemplated, you know, some of them were listed, some aren't. But I'm just, as an example, you know, sort of those kinds of scenarios can arise. So, and it's obviously quite a small list if you compare it to, for example, and there's sometimes confusion on this, the United States famous no-fly list has something, I mean, it has thousands of names, but it's a very, very different kind of list. And it's also, and this is one of the issues I have, the criteria for listing by the Security Council, the one which I must examine solely, is association to Al-Qaida. It's not terrorism. And that's a big, big difference, because many of the domestic lists are about those who support terrorism writ large, which is a huge different question. So sometimes, you know, I might have cases where they might be involved in criminal activity, or they might be involved in even in terrorist activity, but the issue I have to address, and that's what the rule of law, of course, is all about, is are they associated to Al-Qaida? And who advocates for me? There is well, obviously there is still a great body of NGOs, academics who are very interested in the question of fair process and the sanction regimes. There is what's called the like-minded group of states who have been extraordinarily influential in this area. Usual suspects, I like to say, the Scandinavian countries. They're actually formally known. It's not secret in any way. Germany, Costa Rica. I hope I don't forget anyone. If I do, I'll add it to the editing. But they do a tremendous amount of advocacy work. They do, obviously, political diplomacy work. They were instrumental, those group of countries, in the creation of the Office of the Ombudsperson. The name came from the Scandinavians because it's originally ombudspersons are, well, it's ombudsman originally is I believe a Danish concept. So there are, you know, many advocates. And I certainly advocate for myself. I have to be very careful. It's not for me to advocate on things like, should this regime be extended to other sanction regimes? That's a matter for states. You know, there's certain broad questions. But on things like, you know, where do I see weaknesses in the process? Where do I see unfairness in the process? Those points, the follow-up point, for example, those issues I write to the council, I speak about, and I feel that's within my purview. For example, one of the things when I first took up the job, the designating state, that's the state, that's the term we use, that's the state or states that put the person onto the list, or put them forward for listing. Still a committee decision, but it's obviously the state that has the critical information. And from my point of view, a petitioner must know for fair process, must know who the designating state was, because you can imagine if your relationship with the state is not so good, that might be a factor you want to raise in your submissions. But that information was not available. It's still not available, but I wrote about it repeatedly. The special rapporteur spoke about it, and in the last resolution, they've reversed the onus. So now, unless a state specifically objects to having their name released, and very few have, then I'm able to release that information. So that's just an example, you know. It's, again, by being annoying, and just, you know, and you know, we write about it over and over again, you speak about it, they get tired, eventually you make some progress. So there's a fair bit of advocacy, which I think is a really good thing.
Please approach the microphone.
I'm just curious, of the people that have been delisted, I recognize that very few cases are alike. I'm just curious if you've noticed any trends or recurring issues that have come up in any or all or a handful of those cases.
Yeah, it's interesting, and it's always a bit difficult because to date, and this is something that certainly I write about and others write about, to date my reports are strictly confidential to the committee. I can't even reveal to the petitioner or publicly what my recommendations are, though it's not hard to figure out, because I'm able to say there's not been an overturn or a Security Council reference, so, people can figure it out. But as a result, I'm sort of guarded in what I can say. But interestingly, it's not been things that when I first took the job I thought it might be, people arguing mistaken identity, or it's been more factors of, because I operate to this lower standard, it's not a criminal standard. Council's made it very clear, this is not punitive, it's preventative. Because you're operating to a lower standard, you can base these listings on, reasonable information or inferences that you're drawing from information. And I've had several cases where what became an issue was whether those inferences were correct. And because I take the approach of saying, I'm looking at all the information now, critically important, it includes things the petitioner brings forward. So I have had several cases the petitioner says, yeah, okay, I can see why that would look pretty suspicious and might even reach the threshold, but here's what the story was, and sometimes they can produce documentation. So there's been more of that than I expected. But I think that's an interesting point. I think it's okay in a preventative measure and a measure that's meant to change conduct to rely on a lower standard and those inferences that you draw, like you do with a search warrant application in my old prosecutor days. But it's important then that you allow a response to that and you take that information into account. So, and that's what I would, say that, each case really is different and very, very interesting. And sometimes it's changed circumstances, people who have changed and the situation they were tied to has changed. So lots of sort of interesting scenarios.
Other questions?
Judge Prost, I wonder, given it would seem that the high rate at which cases have been delisted, people have been delisted, wouldn't it make more sense for the ombudsperson to adjudicate, or not adjudicate, but examine these cases at the front end, before the actual listing has gone through, so that there is not this stigmatizing effect to those who really shouldn't have been delisted?
Yeah, there's 2 points on that question. One is, and the front end issue has been a point that's been argued and is still discussed. First, it is, I gave you the numbers, and yes, it's pretty high. But there's some factors that go into that. At the beginning, I spoke about this at lunchtime, at the beginning there was what the Danish ambassador called the low-hanging fruit. There were cases that were really sitting there. I had a case sitting on my desk before I even arrived. There were cases that, I think for a combination of reasons were older, relatively straightforward. And now we're starting to see much more complex cases. So I don't think the numbers necessarily for over the first 3 years are a trend that will necessarily stay the same. But the problem with having a front-end review is it raises this whole political issue, which is, this is the Security Council, which the Charter gives the power to make these decisions under Chapter 7, and there is simply, it is very difficult, if not impossible, to have an independent party reviewing. This is the problem with giving full judicial review, reviewing the decisions of the Security Council, which is what a front-end consideration, although there's probably ways you could structure it. It's much more difficult politically to have that. And while, yes, there is the point that it would avoid, listings and stigmatization, which is always a very important point. At the same time, I'm less concerned about that now, because the day after you're listed, now, you can apply to be delisted. Now, you'll still have to go through the process, but it's much more effective now, and it's much less of a concern now that there is the mechanism. And also, the mechanism has had a real effect on the listings process, because what happens is that a country proposing someone for listing has to provide a statement of reasons, and they keep making the point that these reasons must be very, very detailed, and it has to be a unanimous decision to put someone on the list. So the fact that they know they have that Canadian woman at the end of the process, I think has been a bit of a, well, we better think, whether we agree with her or not, we better think of how she'll look at this case if it comes to her. So I think there's a lot more, strengthening of the process through that end. Not to say that, there's still, as I say, still discussion about it, but I think that's sort of the context in which it's been dealt with.
So let me close by saying that Judge Prost is very persistent, but contrary to what she was saying, nobody thinks she's annoying. In fact, she's the most respected person that I know in the field of international criminal law, and we're very, very privileged to have had you here today. And so please join me in. I have 4 quick announcements, and then I will ask you guys to join us for a reception where the judge will mingle with you and answer your questions one-on-one and talk with the students and the alumni. The first is, if you are not a student and so you can't take international criminal law from me, but you're interested in this field, we now offer the world's first international law Mooc. It's International Criminal Law, a free online course, and it's offered by Coursera. 28,000 people around the world are taking it. I'm teaching it. It's very fun, and there's little flyers about it out in the hall. Secondly, if you are interested in this area, on Tuesday at lunchtime, we are going to have General Mark Martin, who is the chief prosecutor of the Al-Qaida military commissions for the United States, coming to do a presentation. 60 Minutes is going to be here to televise it. So it's a really big deal. We'd like to have a full house for 60 Minutes, so please come back. Thirdly, we have a lot of students who are interested in internships. Next Thursday, we're going to have a special panel with all the students that have internships for the last 2 years to tell you about them. But Judge Prost was telling me that there is the possibility of an internship in her office for the summer or even the fall. So we will we'll see about that. That would be very exciting, I know. And I think that's all my announcements. I may have missed one, but all right. So once again, thank you very much, Judge Prost, and thank you all for coming.